she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction for a first offense. There's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now,
8822, and it's basically it's evidence. Is not, they didn't provide any evidence of an injury or injured party, and
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy.
so to this person on the device just labeled Mac, would you be Stephen Smith?
My Christian appellate name is capital S, lowercase T-E-P-E-H-E-N, capital S, lowercase M-I-T-H.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024, that charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed pistol and a CPL. So it looks like you were also cited for having a window tint. I don't have that citation, which presumably means that it was paid. So again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Okay, thank you. Just a moment. Okay. So, Mr. Smith, as you have likely heard already, you have 3 basic options when it comes to this citation, and these are your 3 options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation, so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Which of those 3 options are you going with?
I want to, may I grant my name to the court and make the court trustee?
Okay.
But the option 3, as your question, I deny responsibility and I have an explanation.
Okay, so if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff in this matter, okay? Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is not a criminal case. It is not beyond a reasonable doubt in this situation. So, do you understand? Do you comprehend everything that I just said?
I do comprehend.
Thank you. Okay, raise your right hand, Deputy Sims, and Mr. Smith, you will have to tell me when it's raised if you're not turning your camera on.
It's raised.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief, Deputy Sims?
I do.
Mr. Smith?
Yes.
Thank you. Okay. Deputy Sims, you may proceed with your testimony.
On 11/17/2024, about 3 a.m., my partner and I observed a black Ford Fusion. It was on Ford Boulevard. I believe it had just turned onto Ford Boulevard with tinted windows. Proceeded after the car. It turned into the gas station there on the corner, and we followed it into the gas station and proceeded towards one of the exits. Before it returned to the road, the driver, Mr. Smith, exited and began yelling at us. At that point in time, we activated our emergency lights and conducted the traffic stop there. We made contact with him, explained the reason that we had followed behind him. And when I approached the vehicle, I looked in the vehicle and I observed a firearm on the passenger seat. At no point in time during that did I hear I have a CPL until after the firearm was located. He was detained, his CPL was verified, he was issued the citations and released.
And did you have any evidence or witnesses or any other testimony that you wish to present?
Not at this time.
Okay. Thank you. Then, Mr. Smith, it is your turn.
I want to mention there's no damaged property or victim under sworn oath. Also, I believe I was being racially profiled. I had been pulled over, which I did stop, and I was let go because I wasn't suspected of any crimes, just as I wasn't suspected of any crimes by him as well, as he mentioned. We had sat in the intersection, which I was in the middle of a DoorDash, and I wanted to get on my phone to see where I was at. When I looked away from my phone, I seen him, the officer, and another deputy, or whoever it may have been, an officer, also sitting in the middle intersection for about 30 seconds, maybe to even 60 seconds. So he could see me through my windshield. While I believe it was racial profiling, considering the area we were in, it wasn't the best area. So when I pulled, which I did use my turn signal, and it was a stop sign, or it was a light, a signal light. So when the light turned green, I turned right with my turn signal. I also turn signaled into the gas station, which I was going to stop to check my phone because, like I told the officer that had pulled me over 10 minutes before, which I'm sure he heard on the radio call, I was door dashing, which I had admitted to both of the officers. He called another officer in response to what he calls me pulling myself over. He never admitted to pulling me over. He said I pulled myself over. I got out the car to explain myself that I was door dashing and that I felt like I was being harassed because I was just previously pulled over. I did not have a firearm on person, and he didn't have a reason to suspect me of any crimes or try to search my vehicle. I was illegally searched on person without my disclosure. I told them I don't consent to any searches, and they were digging in my pockets. I have a legal license, and I'm not suspected of any crimes. So after he said I pulled myself over, he flashed his lights, and they kind of like grabbed me up, and I feel like they assaulted me in a way. And after he figured out that I did have a CPL disclosure, which he never gave me time to disclose because it was not on my person. So I didn't feel the need to because I was not present in my motor carrier for him to be in any type of danger. After he sat me in the car, which I feel like I should not have been detained that way, for about 15 minutes, they let me be on my way with a citation. And I don't believe I deserve the citation. And he doesn't have any evidence of the situation. It's just a presumption with no material.
Does that conclude your testimony?
Yes.
And did you have any evidence or witnesses that you wanted to present?
I have evidence on my phone of me asking him, what their badge numbers was, which they didn't really want to disclose. So I had to look it up on the internet. I have a dash cam, but it was not running at the time.
So before we continue, I do want to apologize because I did actually have the equipment violation citation as well. That is for the window tint. So did you wish to address the window tint specifically?
That's just how the car came. I bought it that way, straight from Ford. So it's free.
In Michigan?
Yes.
Deputy Sims, since I don't think I specifically asked you about the tint either because I had misplaced this on my desk, do you wish to address the window tint?
Yes, ma'am. I'm sure you're aware that no vehicle that comes from the factory has front window tint on it. During his first testimony, he admitted to having window tint and said that we saw him through the windshield, which is not possible at night, but he admitted that there was tint.
May I add something?
You may.
There's they didn't test any window tint for any type of darkness issues or anything like that. It was just kind of an excuse because that wasn't the first reason that he told me that he pulled me over. It wasn't for window tint. And you can disclose that through the video of his own body cam. They said that they pulled me over because he presumed that I was trying to turn around in the parking lot or evade him, but I was door dashing like I told the officer that pulled me over before.
So, Deputy Sims, I believe when you testified a moment ago, you said you had noticed the window tint. Did you want to respond to that to me, please?
I guess, what are you asking?
You had stated that you initiated the stop, or at least you started to initiate the stop based on observing window tint. Is that correct?
So yeah, I mean, I was with my partner. So there's also the part of he came off of Holmes Road, if I remember correctly, turned right into the parking lot, and then cut through the parking lot to go back onto Holmes Road. It didn't seem like there was any intention of him trying to stop at the store or anything like that. So he's also cutting through the parking lot.
May I add?
You may.
I did not try to cut through the parking lot, as I mentioned before, and prove to the officer before I was door dashing. And if I would have been on my phone, then he would have tried to get me for that as well. So I safely pulled over to where I could view where I was. And it was his presumption that I was trying to turn around in the parking lot, but my car wasn't parked.
Okay, thank you. Give me just a moment. So the court is ready to make a decision in this matter. So in regards to the B ticket, that is the equipment violation, basically having obstructed vision with window tint, at this point, the court is finding you not responsible for the window tint, Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter. And that is, again, based on MCL 28.425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL.
Once the legal question becomes narrow, bringing in unrelated grievances usually creates a strategic problem. The issue here is no longer why the stop happened. The issue is whether a disclosure requirement existed and whether it was met. From the defendant's perspective, challenging the entire encounter may feel like the strongest defense, but legally, it can pull attention away from the one fact the court must decide. That's where sovereign citizen-style arguments often lose effectiveness. They attack the system instead of the specific element being evaluated.
To disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction for a first offense. There's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So,
How do I appeal?
You would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So,
Yeah, because I wasn't, as he stated before, sorry, I wasn't actually engaged in a traffic stop. That was the problem.
At this point, the court has made its ruling. This hearing is concluded. I believe that concludes the docket.
The court will call the case of Ypsilanti Township versus Vash Bay, case number 2014-00158.
Paul Barnett on behalf of the township.
Karen Medadish on behalf of Mr. Bay. Mr. Bay, can you say your name for the record?
Vash Bay.
Thank you, Mr. Bay. All right, we're here today for a review. It looks like Mr. Bay is moderately compliant. So, Mr. Bay, you have completed your MAD victim impact panel. Thank you for getting that done. Let's see, when did you get sentenced? In October, no, November. So you're doing good for just starting in November. Thank you for getting those things done. You've completed the victim impact panel. You've been checking in with probation. You're testing 2 times per month. You need to submit proof that you're doing your 12-step meetings, though. We don't
I have proof. Sorry to disrupt you. I had proof. I just lost my sheet because my therapist that I use for outpatient said that she could sign in on behalf of the AA meetings, but I've been looking for it since I've been waiting. I don't know where I did with the paper at it. So,
but you think you can find it?
If not, I could always get one of the gentlemen at the AA meetings to sign the previous times I've been going, because I go every week because it's literally right down the road from me.
Okay, good.
He also did mention, Your Honor, that he is doing therapy at IHA. He said that his supervisor there, or whoever.
Sorry to disrupt you. It's my therapy. So every time I go, I have to drop there, and then on top of that, I go to the IHA urgent care, and I drop there too. They got me dropping like whenever pretty much twice a week almost. On top of going to the community corrections, and I haven't been going to community corrections for the last week and a half because of I don't have a vehicle because I hit a deer over vacation, so I don't have a vehicle right now. It's being worked on as we speak.
So, Your Honor, we mentioned this for 2 reasons. First reason is that he is doing therapy. He said that someone in charge there called Constance should have sent everything to Miss Johnson. I don't know if Miss Johnson is in receipt of that. That's the first reason we mentioned that. Oh, Miss Johnson.
Sorry, I don't have anything from Miss Shuby as of yet, so he may want to resend it and then make sure that we include Mr. Poppenhagen, because moving forward, Mr. Poppenhagen will be his agent.
Okay. Yes. Okay. So I'll talk to Mr. Bay, make sure that he sends the proof of the 12-step meetings as well as the outpatient assessment that he did to Mr. Poppenhagen. But Your Honor, he did mention that he wanted to ask if he's able to drug test at the urgent care that he mentioned, since it's closer to him, instead of having to drive to Ypsilanti. He lives in Mayland, Mr. Bay, you said?
Myland, ma'am.
Sorry. I'm not from Michigan. I'm not familiar with all the cities. Yeah, I'm sorry about that.
Thank you. Do we know if those drug tests are supervised, meaning does someone watch as he provides the sample?
No, ma'am. No.
Mr. Bay, they need to be supervised for them to be appropriate to make up. If you want to replace the community corrections, they need to be supervised. So unfortunately, you are not going to be able to switch it out. Right?
Okay,
correct, Your Honor?
No problem.
That's correct. They have to be. I've always appreciated your honesty and forthrightness, Mr. Bay. I just want to tell you that. I'll tell you what I will do. I'm not gonna just eliminate community corrections, but I will, let's see, he's doing 2 times a month. I'll reduce it to 1 time per month. I'll do that for him based on his honesty here today. And I think that he's taking this really seriously. So I hope he continues that. I believe in rewarding people for doing what they're supposed to be doing. And so that's what I'm willing to do. Mr. Barnett, do you have any objections to that?
No, I don't, Your Honor. That's fine.
So what we'll do is we'll adjourn it for 90 days and give him time to get his 12-step meetings in. He should be submitting those on a monthly basis with his monthly reports.
Yes,
so that
ma'am.
when we come back, we're not having this issue of trying to, and it helps him too, because if you misplace it or something comes up, you're not trying to recreate 90 days. You're trying to recreate, 30 days instead of 90 days.
Yes, ma'am.
And then the other piece of this is he can get that assessment in like he's supposed to and keep working towards his community service. And I'll see him back here in another 90 days. He got a total of 9 months on probation. So December, January. So he'll be eligible for early discharge if he's completed everything by that time. So the next review will be on April the 9th, 2025 at 10 o'clock a.m.
Your Honor,
Yes.
I will mention to Mr. Bay, and he may want to let Ms. Shuby know as well. The probation fax number during the transition for the court renovations is disabled at this time, so all faxes need to go to the main fax number. If Mr. Bay has questions in regards to what that is, he can contact probation so we can get that information to him. They may have been trying to email the previous or fax to the previous email or fax, which is why we don't have the information.
Got that. So there's a new fax number because we moved to a temporary space, if you didn't know that, and the other fax number isn't working. So you have to call probation, get that fax number. Okay, Mr. Bay?
Yes, ma'am.
All right. Thank you, sir.
Thank
Take care
you.
of yourself. I'll see you in April. Okay.
See you. Have a good day, ma'am.
Bye-bye.
I believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona. I am not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kirnar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context. These are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, with this a constitutional court. The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test, and if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms. The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure. In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract, to substantiate a debt or court claim. They did not. More documents I found. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. You know, I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for, it incentivizes them to collect more child support. The main argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22. And it's basically it's evidence, they didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss this without prejudice.
These two hearings show a difference that appears again and again in courts. The outcome is often shaped less by how strongly someone disagrees with authority and more by how well they respond to the legal issue in front of them. In the first case, the court repeatedly narrowed the discussion to a specific statutory requirement. The defendant focused on profiling concerns, jurisdictional objections, searches, and the legitimacy of the stop. Whether those concerns were important or not, they did not directly answer the question the magistrate believed she had to resolve. When a court is deciding a limited issue, expanding the dispute can sometimes reduce the effectiveness of a defense because the judge is still required to return to the controlling rule. The second hearing followed a different path. The court was evaluating compliance, documentation, and progress. The defendant was not perfect. Some paperwork was missing and some requirements were unfinished. But the discussion stayed connected to the conditions the court was monitoring. That allowed the judge to evaluate effort, cooperation, and credibility rather than spending time sorting through arguments about authority or jurisdiction. A common theme runs through both proceedings. Courts tend to reward information that helps them make the decision they are legally assigned to make. They tend to give far less weight to arguments that do not change the legal question before them. For viewers who follow sovereign citizen cases, that distinction matters. Many disputes are not decided by who speaks the most or raises the broadest challenge. They are often decided by whether a person addresses the specific rule, requirement, or obligation that the court is actually examining. Sometimes the smallest strategic choice becomes the most important part of the case.